Hello, my name is Lorna Henry. I am a staff attorney in the Foreclosure Legal Assistance Project, which is a part of the statewide advocacy support unit at Maryland Legal Aid. I'm here to talk to you today about what you can do if you want to file a new bankruptcy case, but you've already had one or more prior cases dismissed within the last 12 months. It's important to keep in mind that when a Chapter 13 or Chapter 7 case is dismissed, the debtor loses the ability to file a new case within 12 months with the full automatic stay in place. Different rules apply to renewing the automatic stay depending on whether or not you fall into one of two categories. The first category is whether you have had one case previously dismissed within the last 12 months versus whether or not you've had two or more cases dismissed within the last 12 months. And these rules apply to whether or not you are trying to file a new Chapter 7 case or a new Chapter 13 case. However, the stay is more important, one might say, for Chapter 13 cases because the consequences may be more severe. The debtor may lose their home, for example, if they're filing to prevent a foreclosure sale. If only one bankruptcy case has been dismissed within the last 12 months, the automatic stay is in place for 30 days after your new case is filed. The stay may be extended upon the filing of a motion to extend the automatic stay. Included with your motion should be a notice of objection and a proposed order, both of which should be served on your creditors and all interested parties in your case. You should file this motion with your bankruptcy petition or immediately after you file your bankruptcy petition. And also you should request a hearing when you file a motion. And these things are very important because a hearing on the motion, if it's held by the court, must be completed within 30 days before the termination of the stay. If your motion is not granted, the stay expires at the end of the 30 days, subject to other factors which are included in the rule governing this area, which is 11 U.S.C. Section 362C3. What do you do if you had two or more cases dismissed within the last 12 months? Well, in that case, there is no automatic stay in place, and therefore creditor action may go forward. So for example, if you became aware of a foreclosure sale on your house and the sale date is scheduled for January 15th, if you file a bankruptcy case on January 10th and you've already had two or more cases dismissed within the last 12 months, there is no stay that would allow you to prevent the foreclosure sale. You have to file a motion to impose the automatic stay, and you have to file it immediately. Similar to what you would do if you're filing a motion to extend the stay, here, for your motion to impose the stay, you file a notice of objection and a proposed order, which you will serve on all of your creditors as well as any interested parties in your case. You should file this as an emergency motion with a shortened response period if there's any creditor that could take adverse action against you, because legally there is no stay. You must file your motion within 30 days. However, like I said, if there's any chance that a creditor can take adverse action, such as selling your house at a foreclosure sale, you want to file this motion immediately, and ideally you want to file it the same day as you file your bankruptcy petition. If your motion is not granted, all creditors will be able to proceed immediately upon the entering of an order denying your motion, despite the fact that you filed a bankruptcy case, because like I said before, there is no stay once you've already had two prior cases dismissed within the last 12 months. Now, what specifically should you include in your motion? Some of the things you want to include are specific details about your prior cases, such as the case number, the date that you filed the case, as well as the date that the case was dismissed. So if you've had 3 cases dismissed previously, you're going to include 3 case numbers, 3 filing dates, as well as 3 dismissal dates. You want to include whether the motion seeks a stay as to all of your creditors included in your bankruptcy petition or just one creditor. You want to include reasons why this new case is being filed in good faith and why you are likely to be successful in following through with this bankruptcy. And you want to include any change in your personal or financial circumstances. Remember, the court is looking at the fact that you've already had cases dismissed, so you want to provide sufficient support as to why this time will be different and you will be able to follow through. A case is presumptively filed not in good faith for a number of reasons, including the following. The debtor failed to file or amend the petition or other documents as required by the court without substantial excuse. Number 2, the debtor failed to provide adequate protection as ordered by the court. Number 3, the debtor failed to perform the terms of a plan that has been confirmed by the court. Number 4, there has not been a substantial change in the financial or personal affairs of the debtor since the dismissal of the last previous case. A presumption of a bad faith filing can be overcome by clear and convincing evidence. There are a few practice pointers I want to share with you. Number 1, you compute that 12-month period by counting from the date the case was dismissed rather than the date the case was closed. Sometimes those dates may be different, and if they are for you, then you use the date the case was dismissed. Number 2, if the previous bankruptcy was discharged rather than dismissed, you don't need to file a motion to extend the stay or to impose a stay. And the last and final practice point is for married couples. If there is not a strong reason for you to file a joint case, then it may be advisable for only one spouse to file the case. And if the case is involuntarily dismissed, the non-filing spouse can file a new case within the 12 months of the dismissal without having to file a motion to extend or impose a stay. Finally, I just want to emphasize to you that it is very, very, very important that whether you have only one case dismissed or whether you have 2 or more cases dismissed, you file your motion as soon as possible. Remember, within the first scenario, if you only have one case dismissed, you have a stay in place for 30 days. So your motion is going to request that that 30 days be extended for the remainder of the bankruptcy. In the second scenario, if you've had 2 or more cases dismissed, there is no stay in place. So upon the filing of your bankruptcy petition, a creditor can still go forward with the adverse action you're trying to prevent. If there's one takeaway from this presentation, this is it. Whether or not you've had one bankruptcy case dismissed within the last 12 months, or you've had 2 or more cases dismissed within the last 12 months, file your motion with your petition. Do not wait. And also, keep in mind whether or not there's a stay in place when you file. Thank you for watching this video, and I hope this information was helpful.